in what our Supreme Judicial Court yesterday called these extraordinary times. I also want to acknowledge the extraordinary work of the Clerk of the Appeals Court, Joseph Stanton, and Law Clerk Megan Sullivan, who have worked quickly and late at night and over weekends, or at least this last weekend, to make possible this video conference setup. Many of us at the court have been concerned about the rights of litigants to make their arguments before us, and in particular to allow counsel to hear the court's concerns about their arguments, to make sure we understand best what you each are arguing, and to have the assistance that provides in reaching the best decision in our cases. What Clerk Stanton and Law Clerk Sullivan have done will enable us to provide parties appearing before the court the greatest degree of procedural protection of their rights to liberty and property possible without a physically in-person hearing, and it will provide dramatically greater protection than any previously available alternative of their due process rights meaningfully to be heard by the tribunal hearing their case. And that enables us to serve our essential function of preserving the rule of law during these unprecedented times when it is under real challenge. So we're grateful to them. The work they and the other court staff are doing is unsung. And although they may never know it, not just this court and its litigants owe them a debt of gratitude. The people of the Commonwealth do as well. With that, we will turn to the case before us, which is number 19-1490, DCF versus Mother. I will remind the parties that this is an impounded case and therefore they should not use the actual names of the parties. The argument rules are 15 minutes per side. We have no rebuttal. It's my understanding that the appellees will be dividing their time 10 minutes and 5 minutes. You should let us know if that's not right, but that's our current understanding. And we will hear first from Appellant Mother, and that means you, Attorney Krasner.
Thank you. May it please the court, I'm Sherry Krasner on behalf of Mother. My client and I thank the court for allowing this motion and allowing this case to be heard as all other child welfare cases are heard because of the significant liberty interests at stake. I'm not here to tell you that the judge was unreasonable in her concern about the challenges Mother will face if she is given the chance to parent her two children together. My client herself acknowledged those concerns at trial, talking about her relationship with her daughter, the subject child, as a work in progress. Worry and concern, however, no matter how legitimate, isn't the way that these cases are decided. They are decided on evidence. Clear
Attorney
and
Krasner, if I could ask you a question, this is Judge Blake. Your brief makes a lot of the fact that the judge made a finding concerning when your client could versus has to leave the program that she was in. If we were to conclude that that was an erroneous finding, why does the rest of the decision not stand?
Because that's not the only erroneous finding that the judge has made. I think it's a significant one, but it's not the only one. And
but for purposes of my question, if you assume that that's the only one that we think is erroneous, what happens to the rest of your argument?
There's still evidence that the court ignored, that the judge ignored. She makes much of the fact that she found Mother to be genuine in her recovery, but that wasn't sufficient. However, there was evidence introduced by DCF from Mother's current treaters. And those were treaters who talked about Mother's exceptional progress in treatment, about Mother having a devotion that was rarely seen in people in this program. And two of the treaters specifically said that they wanted to be advocates in court for Mother. And the judge, it's not that she didn't give weight to it, she ignored that salient evidence. So that's also another reason why there's problems with the decision. There's also
What
very
is
important.
what is the basis for your statement that the judge ignored as opposed to giving less weight to that evidence of more recent recovery?
She doesn't mention it. There's nothing. The only evidence that she talks about mother's current treatment is the statements that mother makes at trial. But she says nothing about documentary evidence. And again, this was evidence introduced by DCF that talked about the excellent progress that mother was making. And that's at the record appendix at pages 133 to 137. So again, it's not that she didn't give it sufficient weight. It's as if it didn't enter into the calculus at all. Another problem, to go back to Judge Blake's question, is the issue of the notion that because this treatment was happening it was coerced treatment, it was court mandated treatment, that somehow that meant that there was no guarantee that would work. And again, that's contrary. The judge seems to have made that up out of whole cloth. That's not what adoption of surrogate talks about. That's not what the SJC standards on substance abuse, and those are appended to my brief, that's not what they talk about. There's no idea that merely because treatment occurs because it's court mandated, that it won't continue after mother is no longer in the program. There's
But
also
would you agree though, counsel, that at the time of trial, your client was not currently at least available to parent this child full time?
yes, and my client conceded that at trial, and that's why if
So
the
then
court has,
the
sorry.
question becomes, how long does this child have to wait?
And I understand no one is saying that it's an indeterminate, open-ended time, but what makes this case different, I would say, from the SJC cases of Nancy and Elena is, and the case out of this court of adoption of Cadence, is that it wasn't just open-ended. It wasn't just make it last forever until mother is ready. Mother was in the program for 5 months at the time of trial. She testified that she needed some additional time, and there was testimony that most people in that program remain there from 4 to 8 months. So there were some parameters that were laid out. And again, too, if the court here, well, there's several problems. First of all, this case began when the child had been in care for about 11 months, and strike that, for 13 months. And it's unclear why the department felt a need to go that quickly, where the statute provides that the petition should be filed after 15 months. So there's that issue.
Well, if I can ask, I mean, until shortly before trial, of course, all the DCF had was that despite its really extensive efforts to try to even contact mother, she had abandoned the child. So I think that explains the decision to move toward adoption. But what I'm trying to figure out is this, and it's essentially like Justice Blake's question. We have a child who has been with another family from birth and whose mother abandoned her. And obviously, if she had not gone into rehab, maybe there wouldn't have been, the trial might have taken 5 minutes. I mean, there wouldn't have been anything to say, but she did. She went into treatment, and commendably was apparently doing extremely well in that treatment for whatever it is. She wasn't living on her own and so on, but whatever it was, she was doing as well, maybe as one could reasonably hope. She said she had to stay some more time. I feel like I may have seen some evidence that she said she wanted to stay till October, or she hoped, something like that. So we're talking about whatever, some number of months. And my question is, the judge has to find that the inability to parent, the unfitness, will continue indefinitely into the future. When a child is 1 year old, has met her mother, aside from at birth, literally 4 times for an hour each during that time, and has a whole other parent and family and doesn't know this person, how long is indefinitely into the future? Is 3 months? That's another quarter of her lifetime, or maybe it's only 3 months. Till the next October, now she'll have lived 2 years with someone else. Are we going to take a child away from the only mother she's ever known after 2 years to be with someone she's only, even assuming you're right, that everything is going to go great? How long? What do you have a sense of what the answer ought to be?
Several things. First of all, the judge here, as to the finding about whether this will continue indefinitely into the future, and that's finding 112, she herself, the judge says, she's not certain whether mother will be able to do this. And so if she's uncertain that this unfitness will, or this newfound fitness will continue, I think just on the basis of that termination is not warranted under our statutes and decisional law. There's also, it is true, the first 9 months of this baby's life, mother, I'm not going to try and justify it. My client doesn't want me to justify that. But, and the department made an internal decision after 9 months to change the goal to adoption. But the decision that they made before the court, asking the court to approve the goal of adoption, happened in October of 2018, which was after mother had been in the program already for 4 months, had done well. There were no concerns about mother's continuing progress at that time. So I think that's the problem, that their idea that, well, this train has already left the station and we need to go forward. It's unclear why they felt that need in October to ask the court to terminate. Could they have asked the court to make a finding of permanent unfitness? And my client would have stipulated to that. I think the record, she so states that, if not explicitly, implicitly states that at trial. And then anyone is free to file.
Can I interrupt
Please.
you there? You're saying that your client stipulated to her permanent unfitness?
That she says on the record that she does not want, she knows that she cannot take custody back of the child at that time, which essentially was an implicit concession of unfitness, or really unavailability in her case because of the requirements of her program. So what I'm saying is, if the court at that time had found mother permanently unfit, and then 6 months later, the department could have filed a petition for review and redetermination. And the basis of that could have been, well, there just hasn't been sufficient progress, sufficient change. And that in itself would be a basis for that petition to be filed and to be heard. So again, we wouldn't be talking, oh, this is going to last forever. The court at that time could have entertained that petition. And if mother still wasn't in a position to take the child, either because of her unavailability or her progress in treatment, the judge could have made a determination then to terminate rights, and this child wouldn't be left in limbo. So again, unlike the Nancy case and Elena and Cadence, it wasn't as open-ended, and there would still be a recognition that the interests of the child are paramount, and that you can't just let a child linger indefinitely. And that did not have to happen here. The court could have simply said, mother is permanently unfit, mother is unfit, she's committed to the child to the permanent custody of DCF, and either party could have come back 6 months later or sometime after that and filed a petition for review and redetermination.
Can I ask you, just in the interest of time, two of your arguments, your brother counsel suggests were raised for the first time on appeal and therefore waived, and that is the reasonable efforts of the department during the pendency of the case and the issue of sibling visitation, which appears to perhaps only have been argued in closing argument. Could you address as to the issue as to whether those are waived?
Sure. Well, first of all, the issue was not sibling visitation. That is not the issue that I raised in my brief. The issue that I raised, and I talk about this in my reply brief, Your Honor, is it was the idea in thinking about the best interests of the child that the judge did not consider that the subject child had a younger sibling, only 13 months her junior, and that the benefits of being reared together, raised together with that child, that should have been part of the best interest determination.
But was that raised below?
There certainly was a lot of testimony about the issue of the younger sibling and about how the two children related during visits, and but implicitly the idea that there was a younger sibling, that mother was successfully raising that younger sibling, and that it was in the child's best interest, or at least the judge should have considered. I'm not saying it was dispositive, but the judge should have considered that being raised with your biological sibling, that there are benefits that inure to your best interest in that sense, and there certainly is case law that supports that. As to the issue of the services, that admittedly that's more of an uphill battle here, that was not explicitly raised, but certainly as a defense to whether or not mother's unfitness was temporary or not, and that can be raised now on appeal in adoption of Alona, and certainly the court could look at whether but for the department doing more to get mother into a program where she could parent both children together, that we wouldn't have been where we were.
So what case do you think is most factually similar to your case?
On which issue? As a general principle, I look at adoption of Linus, which is a case that talks about concern not being a substitute for evidence. And I think the facts aren't the same, but just that notion that, yes, we understand that there were worries and concerns and challenges, but that the evidence here didn't rise to the level of clear and convincing such that rights should be terminated.
Okay, I see that your time has expired. Are there other questions from the panel, though? No? All right, excellent argument, Attorney Krasner. Thank you very much. Very helpful to us. And of course, we also have your brief. We will hear next, I gather, Mr. Peterson, Attorney Peterson, you'll go first for 10 minutes. Is that right?
That is correct, Your Honor.
All right, so we will hear on behalf of DCF, Attorney Peterson.
Thank you, Your Honor. Good morning, Your Honors. I'm Jim Peterson, and I represent the Department of Children and Families in this matter. The first thing I do want to mention, just with respect to that last question, is that sibling, being reared with the sibling, there is no constitutional protection. Unlike the parent-child relationship, there is nothing, there is no, as Hugo states, there's nothing, no constitutional protections for the sibling sibling relationship. So to the extent that there is that, it clearly was considered, but there's no protection for it. And there was no pre-existing relationship between the two of them, between the two siblings. It only met for about 2 hours, it appears, and it physically touched hands once. But Your Honor, it does seem that mother is.
I need to interrupt. I took your sister's argument not to be that there's a constitutional right for a sibling to see the other sibling, but instead that in assessing the best interests of the child, that contact with the sibling is something to consider.
With this one, there was no, and again, as you look at, they had no relationship. It's really an arbitrary, it could have been anybody. That child in this case has as much of a connection with somebody else, some other child that she has met for a mere 2 hours, as she does with baby at this point. And there's really nothing there. While it would be wonderful if they could, that's just simply, there's nothing that requires that in the looking. This is a case, though, that if you'll excuse me here a minute, as I look through, so mother does apparently agree now. She did raise that she was not unfit in her brief, but does agree now that she did admit she was not capable of taking the child. And the question here is just that: how long do you wait, and how long do you do this? The problem with the judge was not discounting this court-ordered treatment. This was not something that she did. She was simply comparing this. The judge had to weigh mother's recent successes and her progress in this court-ordered treatment with her history that we knew and which has been developed both well in the trial and in the facts. And as part of that, she had to consider this current sobriety and success. Where does this come from? How does this happen? Is this mother on her own? Is she really going out there? There's no question she was doing very well with this treatment. The real question
Counsel,
is—
let me ask you this. At page 35 of your brief, you say that even if it was error for the judge to make the determination that she couldn't leave her program, and you quote, I think, to the Olga case, that it was not central to the ultimate conclusion. But it seems that her ability to leave that program was very much bound up in the judge's ultimate determination. So tell me why I'm wrong.
Oh, Your Honor, the real issue, and as you read through the judge's findings and conclusion, what she's really doing in the entire thing is trying to determine, will mother, when she gets out in the community, will she be capable of maintaining her sobriety? Because there was clear evidence, not just of the abuse, but of the nexus between that abuse, substance abuse, and the abandonment and neglect of child. So the issue was just that. When she gets out into society, into the community, when will she be able to properly parent this child, or will her sobriety be at risk? Which, again, there's a history of that she's failed to do that. The exact date on when she's released then isn't really, or whether she's available immediately or not, isn't as important. I would note as well that the judge did consider, well, maybe I can wait on this. The judge is fully aware. There was testimony. Mother is on probation, was on probation in drug court until the end of 2019. We also know that, from the record, that there was this very intense inpatient program right now that she was in, and then it steps down. You step your way down, so that from the time of the trial for a year, whether no matter how this goes, mother is not going to be living freely in the community in a situation where she can really be tested. She's always under the court's thumb to some degree at that point.
Can I
Granted,
ask you, I'm sorry to interrupt. Do you want to finish?
No, that's good. Thank you.
I have I think it's almost a metaphysical question. As I understand it, and please correct me if I'm wrong, the judge has to find that her unfitness will continue indefinitely into the future by clear and convincing evidence. And yet, it's not a determination of a past fact where you might easily find clear and convincing evidence. She's trying to figure out, is it likely? How likely is it that this is going to work? Obviously, it might. We hope it does. She ultimately concluded that it was likely to not work. I don't think she denigrated the mother's efforts. I think she credited them, really. But how do we fit those two things together? Clear and convincing evidence of a prediction.
Your Honor, that's a good question. And the issue that the judge had was, she did have this history. She did have an indication of what happens when mother gets sober and can maintain that for a period of time. And then even in this situation, and now I'm referring to her when she gets the sober before the birth of child, she goes into the hospital, and the mom's version, which I will admit, DCF did not fully believe, it's clear from the record, but under mom's version, she never used during that period of time. She never used before going into the hospital. She has the child. She's in a spot where we know she's sober. She's in a spot where now DCF is involved, and they're assisting, trying to get her into a program, to get her housing, to get housing for the children. And she wants to do it. She clearly has an expressed desire. She's ready to go. She wants to do this. And she leaves the hospital and falls off the face of the earth to DCF, other than serendipitous meetings that we encounter. So the judge has this evidence in front of her, and she's got to try to look into the future and how long does this go? What she didn't have, she had no evidence that the judge she could rely on to conclude that mother's recent successes would continue into the future. And that's the real issue here. I think that's where it does become, where this really becomes the issue, that she has to make a decision. She can't predict the future. Everyone hopes for success, but there's no evidence here that the judge can rely on that she can succeed in this after that the recent successes will continue. And this is where she gets into the program. She's not discounting the program itself, this court mandated program. What the judge is doing is effectively saying, this is different. This is not just somebody going to get help in managing to maintain sobriety. This is somebody who doesn't have to worry about how you put a roof over your head and pay rent and put food on your table. And remember, mother was homeless before this and was receiving assistance. She didn't have regular employment. She now doesn't have
do we know from the record, I know she started using heroin at 16. Is this her longest period of sobriety that's at least apparent on the record?
It is. In fact, it appears from the record that the first time she tried to get sober, and did for a period of months, which again, the judge can see, and then failed, that was the only time ever she had first tried to do it. She had no desire, in fact. She's very forthcoming. Mother was, we all hope this is successful for mother. Mother was not trying to hide the ball here from DCF or anybody, apparently. She was telling them, I never wanted to get clean until I had the child. But it's when she saw the child, and then immediately thereafter, she fell right off, right back went right back to a place that she had described herself as toxic and a trigger for her abuse. Even though she was getting the assistance at that time in the hospital from DCF, trying to locate a place for her to go so she wouldn't have to do that. And yet she rejected it, even though she had these very real feelings, and that I think the judge credited all of that, that she really cared, she really wanted to. But then she didn't even try to get back with this child until the end of August of 2018. And in the end of August, this is after she's been in custody for 2 months. She's been in jail. She didn't tell the department. The department had to find, the social worker was calling probation to find this out, and going to court and meeting mother and going to the jail. Mother didn't call when she got to the treatment program. Mother waited for a period of time before she ever expressed any interest to try to start the work of getting the child back. And that's a problem that with how the judge can then perceive, how is mother going to do when she gets out in the community? This is mother, even when she is in custody and in starting to go through the program, she's still not reaching out to try to get the things done that she has to do. But while she's in this program,
your time has expired. Are there other questions from the panel? No. Another excellent argument. Thank you very much, Attorney Peterson. Very helpful to us. We will hear last from Attorney Rosenthal, representing the child.
Good morning, Your Honors. Stephen Rosenthal for the appellee child. First of all, I'd like to join with counsel for DCF in asking the court to affirm the lower court judgment. I'd like to have the court look at this matter from the child's point of view. The evidence is very clear that mother has consistently placed her interests before the child's interests, not only when the child was in utero, but continuing up until the time of trial.
Mr. Rosenthal, I have two questions for you. One is, I know the child was born substance exposed, and is there anything in the record that tells us what, if any, conditions or lingering either medical or psychological or emotional remnants there are from that condition? That's my first question. And the second is the most recent case the adoption of Nancy case that deals with the question of how long does a child have to wait, or is there something more recent than Nancy?
Well, the lodestar, I guess, factors that are considered include one where a child is under the age of 4 and has been in foster care for at least 6 months. So I think that that's something by statute that the court should consider. With respect to your first question, the child was on morphine at the hospital, remained in the hospital for nearly 3 full weeks. Date of birth was October 4, 2017. She was discharged on October 23rd. So she remained detoxing that entire time. For 2 months following her discharge, she was followed by a visiting nurse. So from October to late December, just before Christmas, there was evidence not only that she was detoxing, but she was experiencing tremors and other medical sequelae from detoxification. She was also followed after the fact by a pediatrician who specialized in treating substance exposed newborns. So I would say that there was plenty of evidence to indicate that the child suffered from the consequences of being born substance exposed. I'm not going to repeat the entire history of this matter, but I'd like the court to remember that mother initially planned to terminate this pregnancy and then changed her mind, yet continued to abuse drugs for several weeks after knowing that she was going to carry this child to term. Several weeks later, she did go into a treatment program, and to her credit, she remained sober for about 4.5 months, the same length of time that she had remained sober as of the date of trial. However, she relapsed. Perhaps my brother forgot to mention this, but she relapsed 2 days before this child's birth by consuming cocaine. And there were different versions of the story about how this got into her mouth. But the fact of the matter is that she made a conscious choice to protect her cousin from being arrested with no regard for the child that she was about to deliver. And she knew she was about to deliver. So she was also given opportunities to board with the child, which she didn't take advantage of. She was given information about programs she could enter into, the same type of program she went into with New Day, where she could live with her child in an inpatient type of treatment. And that's when, as my brother said, she fell off the face of the earth. She was described repeatedly as MIA, missing in action. Even after entering the New Day program, she didn't contact DCF to arrange a visit with this child for more than a month. She never even inquired about the child's welfare for a full 11 months. The child's first birthday passed on October 4, 2018, without so much as a birthday card from mother. The mother now, and this is the point I want to make, the mother now claims that she has a plan to care for 2 children, including this child, but she has never articulated, didn't do it at trial, no evidence that she had articulated any plan to assist this child in making the adjustment from living with the only mother she has ever known to living with somebody who is essentially a total stranger. We've heard a lot about what mother has done for herself, but nothing about what she will do for this child. Now, I'd like to Justice Rubin asked about the issue of whether mother was planning to stay at New Day for a full year. And sorry if I was nodding my head and distracting you, but if you go to my brief at page 26, and you look at the record appendix at page 136, you will see that evidence that she disclosed, she stated to a worker that she intended to stay in New Day until she completed it which was going to be at the end of October 2019. That would be a
Okay.
full year in that program.
Your time, I see your time has expired. Are there other questions from the panel? Excellent points that you've made, excellent arguments by all three of you. Of course, we have your brief and we have all the briefs.
Your Honor,
Yes.
may I draw the court's attention to a case that was just decided last week that I think would be relevant?
Yes.
All right, I would ask you to look at the case of adoption of West. I don't have, it's only a slip
Well,
of
why
paper.
don't you, if it's a new citation, it falls within our Rule 16L, why don't you get us a letter with the citation? Would
All
that
right,
be-
thank you, Your Honor.
Thank you very much. That the case is submitted. That concludes our sitting for today. I want to express my gratitude to the court staff for their hard work, not only in developing this, but also in ensuring functionality today and timekeeping and recording and so on. I want to thank counsel for their flexibility in being able and willing to do this by video. And I think with that, we stand in recess.
Thank you very much.
Thank you,
Thank you.
everyone.
Thank you, Your Honor.